The documents were already public. Millions of pages once sealed inside government archives had been released under the Epstein Files Transparency Act. Investigative files, emails, communications, records collected during years of federal inquiries. For weeks, the focus had been on what the archive contained, but by February 2026, the story had begun to shift. The question was no longer only about the files themselves, it was about what institutions would do once those files were no longer hidden. In Britain, police moved first. Authorities detained a former royal figure on suspicion of misconduct in public office. Days later, another high-profile name was arrested under the same legal suspicion. Both individuals appeared in documents connected to Jeffrey Epstein. Across the North Sea, Norwegian prosecutors opened a different path. A former prime minister faced a corruption charge connected to documented ties. A senior diplomat stepped down from her post. Another figure came under criminal investigation. These actions did not represent convictions. They were legal beginnings. Arrests on suspicion, formal charges denied by the accused, resignations amid scrutiny, and ongoing investigations. Yet one contrast quickly became clear. Across the Atlantic, where the documents had been released, no comparable new arrests or criminal charges directly tied to the disclosures had emerged as of the 11th of March, 2026. The files were public. What followed depended on who chose to act. When the Department of Justice published more than 3 million additional pages of Epstein-related records on the 30th of January 2026, the immediate reaction centered on the scale of the disclosure. The release included thousands of videos and images alongside millions of pages of investigative material. Combined with earlier publications, the archive approached 3.5 million pages. For days, analysts, journalists, and legal observers focused on the contents of the documents themselves. Names appeared, historical communications resurfaced. Associations already discussed in earlier reporting were documented again within official files, but the legal significance of the archive was not determined by its size. What mattered was what institutions did next. As February began, the files moved beyond journalists and researchers. Authorities in several European jurisdictions began reviewing the newly accessible material alongside existing investigative records. Individuals whose names appeared in the documents were not automatically accused of crimes. Appearance in the files did not constitute guilt or formal allegation. Yet in some cases, the released records prompted authorities to examine whether public officials had acted improperly in their official roles. Within weeks of the disclosure, that scrutiny began producing visible consequences, not in the United States, where the files had been released, but across the Atlantic. The first visible legal response came in Britain. Andrew Mountbatten Windsor, the former royal who had previously served as the United Kingdom's trade envoy, appeared in Epstein-related documents released by the Department of Justice. In February 2026, British authorities arrested him on suspicion of misconduct in public office.
Andrew Mountbatten Windsor.
The BBC understands that he has been arrested on suspicion of misconduct in public office.
The legal suspicion centered on allegations that confidential material from his time as a public official may have been shared with Jeffrey Epstein. Misconduct in public office is a specific legal category under British law. It addresses situations where a public official is alleged to have abused their position or improperly used information obtained through that role. The arrest marked the beginning of a police investigation, not a determination of guilt. Mountbatten Windsor was released from custody the same day after questioning. As of the 11th of March, 2026, no formal charges had been filed against him. Authorities confirmed that the investigation remained ongoing. In legal terms, the situation reflected an early stage of inquiry, an arrest made on suspicion, followed by release under investigation, while police reviewed evidence. But the arrest carried broader implications. It demonstrated that names appearing in the newly released documents could trigger immediate institutional scrutiny when public office and official responsibilities were involved. Just days after the first arrest, British authorities moved again. Peter Mandelson, a senior political figure who had served in multiple government roles, also appeared in Epstein-related documents released by the Department of Justice. In February 2026, he was arrested on suspicion of misconduct in public office. The investigation focused on allegations that sensitive government information may have been shared with Jeffrey Epstein during Mandelson's time in public office. As with the earlier arrest, the legal threshold was suspicion rather than proof. British police police detained Mandelson for questioning before releasing him on bail. Under British legal procedure, release on bail does not indicate the conclusion of an investigation. It allows authorities to continue reviewing evidence while the individual remains outside custody. As of the 11th of March, 2026, Mandelson had not been charged with any offense. He remained under investigation. The timing of the arrest drew attention because it followed the public release of Epstein-related records in the United States. Yet investigators emphasized that an arrest on suspicion represents the beginning of a legal process. Evidence must still be examined, witnesses interviewed, and prosecutors determine whether any charges are warranted. For now, the case remained unresolved, but Britain had established a pattern: 2 arrests, both tied to alleged misconduct in public office. While British authorities pursued investigations tied to suspected misconduct in public office, developments in Norway took a different legal direction. Thorbjørn Jagland, a former Norwegian Prime Minister and later Secretary General of the Council of Europe, also appeared in Epstein-related documents released in the United States. In February 2026, Norwegian prosecutors charged Jagland with aggravated corruption. The charge was linked to alleged benefits connected to his documented ties with Jeffrey Epstein. Aggravated corruption, under Norwegian law, refers to situations in which public officials are accused of receiving benefits or advantages connected to their official position. Jagland denied the charge. Through legal representatives, he stated that he rejected the allegations and would contest them through the judicial process.
The universal rights explained in the Universal Declaration of Human Rights are not Western values.
Unlike an arrest on suspicion, a formal charge represents a more advanced stage in criminal proceedings. Prosecutors must present sufficient evidence to justify bringing the case before a court. Even so, a charge does not establish guilt. The legal process that follows includes examination of evidence, defense arguments, and judicial review. As of the 11th of March, 2026, the case had not reached trial, but the development marked a significant escalation compared with the investigations unfolding elsewhere. In Norway, the scrutiny had moved beyond suspicion. It had entered the courtroom. Not every consequence of the Epstein document release came through criminal charges. In Norway, one of the most immediate outcomes was diplomatic. Mona Juul, a senior Norwegian diplomat serving as ambassador to Jordan and Iraq, appeared in Epstein-related documents released by the Department of Justice. The records referenced past contacts connected to Epstein's network. As scrutiny intensified in early 2026, Juul resigned from her ambassadorial position. Her departure followed growing public attention to the newly accessible documents and questions surrounding her past interactions with Epstein. The resignation did not involve a criminal conviction. Norwegian authorities did not announce an arrest in her case. Instead, the development reflected another type of institutional response: political and diplomatic accountability. In government service, particularly in diplomatic roles, public confidence often plays a decisive role. When questions arise regarding judgment or associations connected to public officials, resignation can occur even before legal proceedings determine whether any criminal conduct took place. Juul's departure therefore represented a different form of consequence than the arrests unfolding in Britain or the corruption charge filed elsewhere in Norway. It illustrated how the release of previously sealed records could affect careers and institutions, even in the absence of a completed criminal case. The developments in Norway extended beyond a single individual. Terje Rød-Larsen, a veteran Norwegian diplomat and former international mediator, also appeared in the Epstein-related documents made public in 2026. Norwegian authorities opened a criminal investigation examining whether his connections to Epstein could involve complicity in aggravated corruption. Unlike a formal charge, an investigation represents an earlier stage of legal scrutiny. Prosecutors examine financial records, communications, and testimony to determine whether sufficient evidence exists to proceed with charges. As of the 11th of March, 2026, Rød-Larsen had not been arrested or formally charged. The investigation remained ongoing. Norwegian officials confirmed that the inquiry was connected to the broader scrutiny surrounding Epstein-related ties documented in the released records. Rød-Larsen had previously held prominent diplomatic roles, including involvement in international peace negotiations and global policy initiatives. The opening of a corruption investigation therefore carried significance beyond the individual case itself. It demonstrated that Norwegian authorities were willing to examine whether associations documented in the files had crossed into potential legal violations. Yet, the outcome remained uncertain. An investigation can lead to charges. It can also conclude without prosecution. At this stage, the process was still unfolding. Even as investigations continued abroad, the Department of Justice in the United States made one additional adjustment to the Epstein document release. On the 6th of March, 2026, the DOJ published a batch of previously withheld records that had initially been categorized as duplicates or irrelevant files. The correction added additional material to the already massive archive of Epstein-related documents. Among the released records were FBI interview summaries containing allegations involving former U.S. President Donald Trump. The Department of Justice described those summaries as unsubstantiated. In legal terms, such documents reflect statements recorded during investigative interviews, not findings of verified misconduct. The release therefore added new information to the public record without establishing criminal conclusions. Importantly, the March correction did not coincide with new arrests or charges within the United States. Federal authorities did not announce new prosecutions tied directly to the materials included in the additional release. Instead, the correction served as a reminder of the complex nature of large investigative archives. Documents can contain allegations, suspicions, and witness statements gathered during investigations. Determining which of those elements meets the legal threshold for criminal prosecution requires a separate and far more demanding process. By the 11th of March, 2026, a pattern had begun to emerge. The same archive of documents had triggered noticeably different institutional responses on opposite sides of the Atlantic. In the United Kingdom, authorities arrested two public figures on suspicion of misconduct in public office. Both men were released after questioning, but remained under active investigation. In Norway, prosecutors moved further in one case, filing a charge of aggravated corruption against a former prime minister who denied the allegation. At the same time, a senior diplomat resigned from her post amid scrutiny tied to the released records, while another prominent figure became the subject of a continuing corruption investigation. These developments illustrated how different legal systems can respond to the same body of information. National laws define distinct thresholds for arrests, charges, and investigations. Institutional cultures also influence how quickly authorities move when questions arise about public officials. Yet one contrast remains striking. In the United States, where the documents had been released, federal authorities had not announced comparable new arrests or criminal charges tied directly to the disclosures. As of the 11th of March 2026, the files had become public, but the consequences were unfolding unevenly. Some institutions acted immediately, others, at least for the moment, remained still. By March 2026, the Epstein files had moved from secrecy to public record. Millions of pages were no longer locked inside government archives. Emails, communications, investigative notes, and historical records had entered the public domain under the Epstein Files Transparency Act. For years, the central demand had been transparency. That demand was finally met, but transparency did not produce a single, unified outcome. Instead, it produced a series of uneven responses. In Britain, arrests were made on suspicion of misconduct in public office. Those individuals were released while investigations continued. In Norway, prosecutors filed a corruption charge against a former prime minister who denied the allegation, while a senior diplomat resigned from her position and another figure came under criminal investigation. Across the Atlantic, however, the same disclosures had not led to comparable new arrests or criminal charges. As of the 11th of March 2026, the documents revealed connections and prompted scrutiny, but the legal consequences remained different depending on where the institutions reviewing them were located. The archive is now public, investigations are ongoing, and the full institutional response may still be unfolding. If you want more deep investigations like this, make sure to like this video and subscribe to the Silent Dossier TV so you don't miss the next case we uncover.